Please be seated. This is U 2015-8497, Section 394 application between Shandy and Lager Harbour Ferry Services Proprietary Limited for hearing.
Thank you. I'll take appearances.
May it please the Tribunal, my name is Keating, initial S of Council, and I seek permission under Section 596 of the Act to appear for the applicant.
Thank you.
If the Commission pleases, my name is Moore, initial S. I seek permission to appear for the respondent in this matter.
Thank you. Ms Keating,
Yes.
Do you have anything to say on why I should grant permission?
I do, Commissioner. Our submission is that all three limbs of subsection 2 of Section 596 are engaged in this matter. First, it can be dealt with more efficiently if permission is granted. There will be necessarily extensive cross-examination of both witnesses, and we're dealing in this case with an interaction between an employer policy and a critical piece of legislation governing blood alcohol contents of commercial vehicle operators. They're both matters that point to efficiency being assisted by counsel appearing. As to the second limb, it would be unfair for my client not to have the benefit of counsel, given the difficult personal circumstances which are set out in her statement, and which would indicate that she would be assisted at a personal level by having an independent representative here. As to the third, Commissioner, you see we are faced with senior counsel appearing for the respondent in this matter, and it would be grossly unfair to my client if she didn't also have the assistance of counsel.
Thank you, Ms Keating. Mr Moore?
Yes, thank you, Commissioner. Can I echo my friend's submissions in large part? Under 596(2)A, the matter will be dealt with more efficiently. In the hands of competent counsel, the bar table will get through this matter expeditiously and deal with the interaction between the act and the facts and deal with cross-examination in what I am confident will be an efficient and directed way. As to B, it would be unfair not to allow the respondent to be represented because the respondent's human resources officer is absent on leave and is not here at the moment. I'm instructed by the Chief Executive Officer, who's a witness in the case. In the absence of being represented by me today, the respondent would not be able to have its interests properly heard before this Commission. And as to C, well, the applicant's represented by counsel and of course the respondent ought to have the same privilege.
Thank you. Thank you. Having considered the submissions of both Ms Keating and Mr Moore, I am satisfied that taking into account the complexity of the matter, it would enable the matter to be dealt with more efficiently if permission is granted. I therefore exercise my discretion and grant permission for both parties to be represented. Thank you.
Thank you, Commissioner.
Thank you, Commissioner.
We propose to proceed in the following way. I will make a short opening submission of approximately 5 minutes. My learned friend will then seek to do so as well before we move to witness evidence. If that's convenient to the Commission, we will then proceed directly to call our witnesses before both parties will make closing submissions.
Thank you, Ms Keating.
As the Commission is aware, this is an application under Section 394 of the Fair Work Act. There is no contest, Commissioner, as between the parties that my client is a person who is protected from unfair dismissal. The questions in this case are these. Was there a valid reason for my client's dismissal from her employment? And if there was a valid reason, was it nonetheless harsh, unjust or unreasonable for her employment to have been terminated? The position of the applicant is this, that there are 3 critical matters that need to be determined. The first is that on our submission, there was in fact no valid reason for the dismissal. And if the Commission is satisfied with that matter, then we need not go any further. The second is that there was, in this case, as the evidence will bear out, a gross denial of procedural fairness to the applicant that is inexplicable, egregious, and as the Commission will see from the evidence, material in that, had procedural fairness been afforded to my client, it is uncontrovertible that her employment would not have been terminated. The third issue that we say the Commission needs to consider is whether or not, if you're against us on the first point, nonetheless the dismissal was harsh, unjust or unreasonable. And I'm confident that once the Commission hears the evidence that will unfold, there has never been a case that more exemplifies what is harshness under the Act. Coming to each of those briefly, Commissioner, we're dealing here with a single incident that occurred on a single day, being the 9th of January 2015. It's common ground between the parties that on that day my client attended for work with a blood alcohol content of over 0.00. That's common ground and it's not contested. What is contested is what occurred on the balance of that shift. The Commission will hear some evidence about an incident involving the vessel that my client was captain of and whether or not her blood alcohol content had a bearing on how that incident played out. The Commission will then hear that my client was suspended from her employment without pay while notionally an investigation was conducted. The Commission will hear in evidence that during the course of that investigation a number of people were spoken to, but inexplicably not the applicant. When the Commission hears all of the evidence about what occurred on that single day in the context of a 33-year unblemished employment history, the Commission will be satisfied that my client attending for work with a blood alcohol content of more than 0.00 was not, in all the circumstances of this case, a valid reason. As to the second point, procedural fairness, Commissioner, what Your Honour will hear is that my client was suspended from duty without pay on the day of the incident. 5 days later, she was called to a meeting at which she was handed a letter dismissing her from her employment forthwith. The Commission will hear that an investigation took place that did not involve an interview with my client. It did not involve my client being afforded the opportunity to give her version of what occurred on the day and, critically, why it occurred. The Commission will also hear that at the meeting at which my client was dismissed, the termination letter was already prepared. There was no opportunity at all afforded to my client to respond to the allegations against her. Not only would that be inexplicable for any employee, Commissioner, it's particularly inexplicable for an employee with a 33-year unblemished work history. As to the third point, if the Commission's against us on the question of valid reason, was it nonetheless harsh, unjust or unreasonable? From what I've said thus far, the Commission will already hear the tenor of that submission. What the evidence is going to show is that my client has worked for this organisation for 33 years. She's worked her way up the ladder to become a captain of the vessel. She has given her time to training new staff. She has diligently followed all of her employer's policies and procedures. Her work history has not only been unblemished, it has been absolutely commendable. What the Commission will also hear is that my client's husband is terminally ill. On the day preceding the events leading to the termination of her employment, she had received the news that no further treatment was recommended. In all of those circumstances, the Commission will be satisfied that whether or not there was a valid reason, this was a termination that was harsh, unjust or unreasonable for the reasons I've outlined. As to remedy, you will hear that my client would like her job back. You will hear evidence that she lives on a small island with a small population. Her family's lived there for 40 years. This is the only ferry operator on the island and the only employer on the island who can give her employment in the position of ferry captain. For all of those reasons, we say that not only should reinstatement be granted, but it ought to be granted with full continuity of service and compensation for the wages lost between the date of my client's dismissal and the date of reinstatement. Unless you have any questions for me at this point, that's my opening statement.
Thank you, Ms Keating.
Thank you, Commissioner.
Mr Moore.
Thank you, Commissioner. There's little controversy about the key events in this proceeding. The central event occurred early in the morning of the 9th of January 2015, and on that morning the applicant was the captain in charge of a ferry, and while being in command of the ferry, the ferry momentarily careered out of control, nearly hitting the jetty at which it was about to berth. This failure was, as the applicant cutely puts it in her statement, a scary moment for the crew and the large number of passengers who were waiting on the jetty to board. That the fact that that occurred isn't in dispute. It was, we say, an inherently dangerous situation, which most fortunately no one suffered any ongoing harm, save for the distress of the people involved and the shock and disturbance that they suffered. But although no one suffered any loss or harm, that does not obscure the fact, that in this case, the applicant was in control of a very large vessel with a substantial crew and customer contingent on board, which put in jeopardy the safety and well-being of the crew and passengers. And we say, and this is where the zone of controversy comes into focus, Commissioner, how culpable was the applicant for that situation? She was in charge of the vessel, there's no doubt about that, and the evidence will establish, in my respectful submission, that she was under the influence of alcohol at the time. And it is for that reason that culpability rests for her actions in endangering the customers and crew, which, through grace of God, didn't crystallise into any harm. The applicant appears to ultimately accept, in her witness statement filed, that there was what she refers to as a minor breach of the respondent's policy in relation to her conduct. We say that with respect diminishes, for obvious reasons, the gravity of what she did. It was a very serious breach of a clear policy promulgated by the respondent, which made clear that employees were not to work under the influence of alcohol. Notwithstanding my friend's opening, on the statements that have been filed with the Commission, as I understand it, it's not in controversy that 1.5 hours after the incident, the applicant registered a blood alcohol reading of 0.019. Now, in the circumstances of this case, in my respectful submission, and on the balance of probabilities, you'll be able to be satisfied, Commissioner, that at the time of the incident, 1.5 hours before that, the applicant was well above the legal applicable limit to an operator of a vessel, of a commercial vessel, which was in New South Wales, where this event occurred, 0.02.
Am I going to hear any expert evidence with respect to blood alcohol readings and the diminution of blood alcohol content?
No, Commissioner, because those matters, I withdraw that. The readings were taken of the applicant at certain times, and what those readings were do not appear to be in dispute. However, I acknowledge what you asked, Commissioner, which is, will there be any expert evidence as to the rate of change, if you like, or diminution in the readings? No, there's no expert evidence to be called. You're, of course, not bound. This is a civil tribunal and the balance of probabilities apply, so it's not necessary for you to be satisfied beyond reasonable doubt that the applicant was over the legal limit at the time of the incident. So the fundamental proposition the respondent will advance is that a valid reason existed for the dismissal of the employee, and the submission also will be put that there are no other circumstances in the case which render the dismissal harsh, unjust or unfair. Much appears to be proposed to be made of the applicant's length of service and her clean sheet, as it were, in her employment. We say ultimately what that does, Commissioner, is serve to underline the gravity of the applicant's conduct. This was not the conduct of a novice employee in their first couple of weeks captaining a ferry. This was the conduct of an employee who had been captaining a ferry for nearly 30 years, who decided to do so under the influence of alcohol. And we say that that underlines the gravity of her conduct. So there's a valid reason, we say, for those reasons, and we say that there are no circumstances which otherwise militate in favour of a finding that the dismissal was harsh, unjust or unreasonable. It was conduct which was inherently reckless and which jeopardised the health and safety of the public and the crew. Two other points to make by way of opening. This is a modestly sized employer, employs some 80 employees. The an investigation was conducted, and that investigation, in the circumstances of the case as such, Commissioner, that the applicant did have an opportunity to be heard in relation to what she did. It was clear what she reported to the respondent, and the respondent took those matters into account. The task for you, Commissioner, is with respect not to ensure that there is some perfection in the standard of the investigation conducted by the respondent. The task, under Section 387 of the Act, requires you, Commissioner, to consider as one of the matters whether or not the applicant was given an opportunity to respond to any reason related to her conduct, and she got that opportunity. And as to remedy, we say that notwithstanding the applicant's circumstances and her personal circumstances and her period of employment, if you're against us as to liability, reinstatement should not flow for this particular reason. The applicant's evidence displays no insight or responsibility for her conduct in the circumstances of this case. And the respondent has no confidence that if she was returned to employment and entrusted with operating a vessel, that she'd be able to do so in compliance with her obligations as an employee. If the Commission pleases, that is the case that the respondent proposes to make.
Thank you, Mr. Moore. Ms. Keating.
Thank you, Commissioner. I proceed to call Ms Sarah Shandy, who will take an affirmation, and I ask that all other witnesses leave the courtroom.
Mr. Moore.
Well, we would object to that course, Commissioner. The other witness is the Chief Executive Officer of the respondent, who is here in court, and she, Ms Harriet Pint, will be giving evidence in due course. I need her here to give me instructions in relation to the running of the case. The respondent or party to the proceeding is entitled to that. My friend isn't privileged, isn't prejudiced. Ms Pint will be here, and she can be cross-examined accordingly. Otherwise, I can't get instructions from her in the running of the case, if the Commission pleases.
Thank you, Mr. Moore. Ms. Keating, I'm going to allow Ms. Pint to remain in the courtroom during the course of of the applicant's evidence, for the reason given by Mr. Moore that she is the only person here who can provide him with instructions, and it is appropriate that he be able to receive instructions.
As the Commission pleases, I call Ms Shandy.
Thank you, Ms. Shandy.
Please state your full name and address.
Sarah Shandy of 22 Frothy Lane, Stout Island, New South Wales.
Okay, and if you could just repeat after me. I solemnly and sincerely
I solemnly and sincerely
declare and affirm that the evidence I'm about to give in this matter before the Commission will be the truth, the whole truth, and nothing but the truth.
Thank you, Ms Shandy. If I could get you to direct your answers to the Commissioner.
Sure.
Thank you. Have you made a statement in this proceeding?
Yes, I have.
And does that statement run to 25 paragraphs?
Yes, it does.
Is it dated 2 February 2015?
Yes, it is.
Have you had an opportunity to read that statement recently?
Yes, I have.
Is that statement, to the best of your knowledge and belief, true and correct in every particular?
Yes, it is.
Commissioner, I tender that and ask that you mark it, and that is the evidence in chief for this witness.
Thank you. I will mark the witness statement of Sarah Shandy, consisting of 25 paragraphs and dated the 2nd of February 2015 as Exhibit A1.
Thank you, Commissioner.
Thank you, Mr. Moore.
Thank you, Commissioner. Now, Ms Shandy, You commenced with Lager Harbour Ferry Services in 1981, that's right?
Yes, that's correct.
And you qualified as a captain in 1986.
Yes.
So on my maths, you've had about 29 years service as a ferry captain before your dismissal.
Yes, I have.
All right. And over that time, you kept up to date with all aspects of training relevant to work as a ferry captain?
Yes, yes. I completed a few training courses.
Yes, and there's well, you've done a lot more than attend a few training courses. There's an annual refresher course that you've attended, that's right?
Yes.
Yes, and in fact, as a long-serving employee, you've assisted the company with the development of of training for apprentice ferry drivers. That's right?
Yes, that's correct.
And you've mentored staff.
Yes.
And you've worked with Lager Ferries to devise company policies and procedures.
Yes.
And you've been involved in the preparation and delivery of training over the years in helping the company in that regard.
Yes, I have.
Now, would you agree with me that the purpose, well, withdraw that. So would you agree with the proposition that the company maintains an intensive training regime for its staff?
Yes, intensive is one way you could put it.
Yes, and would you, is it your understanding that at least one of the purposes for maintaining that intensive training regime is to ensure that staff and customers are kept safe?
Yes, absolutely.
Working on a ferry is inherently dangerous, is it not?
Yes.
Yes. There are inherent risks to the safety of the public and employees in the operation of a ferry?
Yes.
Yes. And would you agree if those risks are not carefully managed, the safety of staff and customers can be put at risk?
Yes, that's correct.
And that's why safe operating procedures are so critical, yes?
Yes.
Now, you knew from your employment that the company maintained a drug and alcohol policy?
Yes, I was aware of the policy.
Yes. And you understood that it provided, and I quote, "No employee will be allowed to work under the influence of drugs or alcohol at any time."
Well, I object to the question. My learned friend is putting the content of the document to the witness. The content speaks for itself. If he's asking her about her personal knowledge and understanding, that's one thing. But to ask her to confirm that they're the words in a policy is an unfair question when the document speaks for itself.
Mr. Moore?
I'm happy to put the document in front of the witness and then ask her some questions if that assists my friend.
I'd be grateful to my learned friend.
Excuse me. Just showing the witness a letter of 16th of January 2015 from which notified her of her dismissal, which attached the Code of Conduct Drug and Alcohol Policy. Witness, please be shown that document. Just take a moment to look over that, Ms. Shandy. Now, the first piece of paper is your letter of dismissal.
Yes.
You recall receiving that?
Yes, I do.
And it attached the drug and alcohol policy, which is the second piece of paper. That's so?
Yes, yes, it does.
I tend to those documents, Commissioner.
Thank you. I will mark the letter to Ms Sarah Shandy, signed by Harriet Pint, the CEO of Lager Harbour Ferries, dated the 16th of January, and attached to it the drug and alcohol policy as Exhibit R1.
Thank you, Commissioner. Now, you'll see on the policy, Ms Shandy, do you see that it states about a quarter of the way down, I think, I don't have it in front of me at the moment, no employee will be allowed to work, thank you, no employee will be allowed to work under the influence of drugs or alcohol at any time?
Yes, it does say that.
And you understood that was the company's policy?
Yes, I did.
And you'll see that the first dot point, I withdraw that, you'll see that the document says in the first paragraph that the company has a zero tolerance to drugs and alcohol. You see that?
Yes.
And you understood that to be the case?
Yes, I did.
And you understood that the policy was that employees must not consume alcohol or be under the influence of alcohol while working. You understood that?
Yes, I did.
Thank you. And you understood from the policy that a breach of it may initiate action up to and including termination of employment.
Yes.
All right,
Yes.
Thank you. Can I have that document back, please? No, it's mine. This is yours. Thank you. Now, in your witness statement, in your evidence in chief, you've accepted that your conduct on the 9th of January was in breach of the policy. That's your evidence?
Yes, that
Yes.
is my evidence.
Good. And your conduct was in breach of the policy because on the morning of the 9th of January you were under the influence of alcohol while you were driving the ferry. That's right?
Yes, that is correct.
Thank you. Now, you say in your evidence in chief that the company has been very supportive of your situation at work, and I withdraw that the company has been very supportive of your personal situation involving your husband.
Yes, they have been supportive.
It's the case that the company has let you take personal leave to take Michael, your husband, to hospital and to care for him on those occasions?
Yes, that's true.
And the company gave you personal leave for that purpose whenever you asked for it. That's so?
Yes, they did.
And the company ferried you and him to the hospital when you asked for it?
Yes.
Thank you.
Yes.
Now, I want to ask you, I withdraw that. I take it you live on the island, that's right?
Yes, that's correct.
And would I be right in thinking it takes you about 15 minutes to get to your workplace from your home?
Yes, around about.
All right. So, on the 9th of January, you presented for work at the scheduled time of 4:30 a.m, that's right?
That's correct.
So I gather you got up at about 3:30 in the morning?
About 3:45.
Right. 3:45, you think?
Yes.
So that night you had about 3 3/4 hours sleep?
Something like that, yes.
Yeah.
Yep.
And you sat up talking and drinking with Michael from about 8:15 until midnight?
Yes, I think it was around midnight when we went to bed.
All right. And I take it your session with Michael was quite an emotional one, given the news you heard that day?
Yes, it was highly emotional.
And your evidence is that in that time, from 8:15 till about midnight, you drank 2 beers?
Yes, I had 2 beers.
And you had a few red wines?
Yes, about 2.5 glasses, I think.
2.5 glasses. You were keeping track, were you?
I recall that we finished a bottle of wine between the two of us, and I think there's around 5 glasses in a bottle.
So you had about 4.5 standard drinks over 3 3/4 hours?
Yes.
You're quite a slight person. I hope you don't mind me observing that, Ms. Shandy. You would be inebriated with that level of consumption.
I object to the question. That's expert evidence. This witness is not in a position to give any evidence about what her level of intoxication would be.
Mr. Moore.
Well, if my friend's right, apparently that would mean that every time someone has had a few drinks at the pub and is considering whether or not to drive home, they need to go and get an expert opinion about that question. The witness is well able to answer a question of common human experience as to whether or not, in her experience, she would be inebriated after that consumption of alcohol. It's a matter in common human experience that she's able to give evidence about.
I'm prepared to allow the question on the basis that the evidence given is just this witness's understanding of how she was at the time. I don't take it to be an expert assessment of her blood alcohol level at that time.
As the Commission pleases.
I'm not asking you in this next question about the evening of the 8th of January, Ms. Shandy. In normal circumstances, in any other circumstances, would it be your experience that drinking 4.5 standard drinks over 3 3/4 hours would leave you a bit inebriated?
I wouldn't say inebriated. I would have been feeling the effects of the alcohol, but I wouldn't say inebriated.
Bit drunk?
Tipsy.
Tipsy. All right. Now, your evidence is that when you arrived at work on the 9th of January, you had a conversation with Alison Schooner about how much you loved your job and that you said you hoped you'd never have to retire. That's your evidence?
Yes, that's correct.
Now, the situation is it not, that that conversation occurred on about the 3rd crossing of the day.
Yes, I think it was the 3rd crossing.
Right.
3rd or 4th.
So it's not when you arrived at work?
Oh, shortly after. The crossings are quite short. I hadn't been at work for an extended period of time.
Well, how long does a crossing take? It takes about 20 minutes, doesn't it?
Yeah, 15 to 20 minutes, I think.
All right. So the 3rd crossing would be an hour and a half into your shift, would it not?
Yes.
All right. Excuse me a moment. Your evidence is that you spoke to Ms. Schooner soon after you arrived at work. You want to change that evidence now?
No. Thinking back and just referring back to my statement, the conversation did happen shortly after I'd arrived at work.
Well, it happened an hour and a half after you arrived at work, didn't it? Not soon after you arrived at work.
Well, I object to that question. My learned friend is assuming a fact that is not in evidence. As I understand it, Ms. Schooner is not being called to give evidence, and the evidence that has been filed of Ms. Harriet Pint does not go to this matter. My learned friend is not permitted to put to this witness a fact that is not in evidence about which he does not intend to call primary evidence himself.
Mr. Moore?
Well, Ms. Pint is going to give evidence about that, so I'm entitled to put it to the witness. I have instructions to put it.
Well, anything Ms. Pint will say is hearsay. She was not party to the conversation.
Yes, that's true, Mr. Moore.
Well, as Commissioner Hayden said to me last week, an objection like that would cut the mustard in about 1880 in a court. Now,
and it may well cut the mustard in my courtroom
well,
too, Mr. Moore.
This is a tribunal. This is a tribunal which isn't bound by the rules of evidence, and it's a sort of objection which would have difficulty being upheld in a court, in my respectful view. And the Ms. Pint does propose giving evidence about that, and I should be permitted to question the witness on that.
In these circumstances, I am going to allow the question. Thank you.
Thank you, Commissioner.
I think I should just add, Ms. Keating, it may be a question for submissions that you wish to make later with respect to weight.
Indeed, it might also be a question of why Ms. Schooner hasn't been called, and I'll deal with that in my cross-examination of Ms. Pint in the ordinary fashion. Thank you, Commissioner.
Thank you, Ms. Keating. Mr Moore.
Thank you, Commissioner. So you accept, do you, Ms Shandy, that your evidence in chief, that to the effect that when you arrived at work you had a conversation with Ms Schooner, that's not right, is it?
Yes, that's my recollection.
Well, the problem is, isn't it, Ms Shandy, that you don't have a recollection, do you? It's all a bit blurry, is it not?
Oh, no, it's not blurry. I felt slightly tired when I arrived at work that day, but I remember the events quite clearly.
You would agree you felt a bit hungover?
No, I didn't feel hungover. I felt fine. I felt tired because I hadn't had a lot of sleep.
Fresh as a daisy, were you?
No, I wasn't fresh as a daisy. I admit I felt tired. In no way did I feel under the effects of alcohol. If I did, I wouldn't have driven my car to work that day.
And you drove your car to work, did you?
Yes, I believe so.
All right. So, can I suggest to you that when you arrived at work, you either assumed or wished that you weren't under the influence of alcohol?
No, that's not correct. I didn't feel under the influence of alcohol at all. that
Well,
morning.
you tested 0.019 at 9 a.m?
Yes, I think that was the time.
Yes.
Yes.
And the incident where you nearly crashed into the jetty occurred at 7:30 a.m, did it not?
Yes, that's correct.
So you would accept that as a matter of general human observation, that your blood alcohol level would have been higher than 0.019 at the time of the incident?
Yes, it may well have been, but...
So you were under the influence of alcohol?
Oh, yes, sorry. I'm not disputing that I wasn't under the influence of alcohol. I felt fine in myself. I didn't feel like I was affected by alcohol at that point.
Well, I don't understand your evidence, Ms Shandy. You say in paragraph 11, I did not feel under the influence of alcohol. You were under the influence of alcohol and you knew that, did you not?
Oh, I didn't know I was under the influence. No, I felt tired, as I said. I had no means to test myself before leaving to come to work that day.
You don't blame the company for that, do you?
No, I don't.
Like you blame the company for some mechanical error as to why you nearly crashed into the ferry, into the jetty?
I feel like the incident was due to a mechanical failure on the ferry.
When did you never raised that with anyone with the company, did you?
Oh, I didn't raise that with the company because I didn't have the opportunity to. I was stood down, and the next time I spoke to someone at work was when I was sacked in the meeting.
Well, that's... you didn't make mention of this claim of mechanical failure when you wrote to the company on the 2nd of February complaining about your dismissal, did you?
No, I didn't make mention of it then. I'd
Well,
already...
why wouldn't you, if that was the reason? You were complaining about your dismissal. Why didn't you say, hang on a second, it was because there was a malfunction?
To be honest, I probably wasn't thinking 100% clearly the day or two after I'd been dismissed. I was still in shock.
Were you still hungover?
No, I wasn't hungover.
Now, looking back soberly on the events of the morning of 9th of January...
I object to that question.
I'll rephrase the question.
Thank you, Mr Moore.
With the benefit of a clear-minded hindsight, would you now accept, Ms Shandy, that you were mistaken in thinking that you were not under the influence of alcohol when you presented for work?
Looking back now, I wouldn't change the fact that I went to work. As I said, I felt tired, but in no way did I feel hungover or still... I didn't feel inebriated under the effects of alcohol or anything like that.
Well, you scored 0.019 1.5 hours after you nearly crashed into the jetty. you would accept, wouldn't you, that it's possible that you may have been inebriated when you started work?
Look, it's possible, but as I said, in myself I felt fine.
All right. Do you drink very much?
I have a glass of wine or two with dinner most nights.
And your husband hasn't been able to drink because of his medical condition?
No, he hasn't.
Now, as a very experienced ferry captain, I take it you're aware, but perhaps you weren't, that the New South Wales Government publishes guidance about boating and alcohol consumption?
Yes, I'm aware of them being published. I'm not 100%.
Are you aware
What's
that
their
the government...
content?
I'm sorry, I cut you off.
Oh, no, that's okay. I was just saying I'm aware that they've been published. I'm not 100% across the content of them.
Do you know that the government publishes a water safety advice in relation to boating and alcohol consumption?
Yes, I am aware of that.
All right. Can I show you this document? I've got copies of this one. One for the Commissioner. Just take a moment, Ms. Shandy. I want to ask you about the 2 paragraphs under the heading boating and alcohol. Just read that to yourself. You've read that?
Yes, I have.
So by way of background, this is taken from a website of the New South Wales State Government, and you'll see that it states under the heading boating and alcohol, the combination of wind, waves and weather can multiply the effects of alcohol and collectively are known as, quote, boater fatigue, unquote. Persons with boater fatigue are at greater risk of drowning and should they fall into the water, and that goes equally for skipper, crew or passenger. Now, as an experienced seawoman, you would have been well aware of the heightened risks of alcohol consumption on the water, as it's set out there.
Yes.
You didn't think that was a risk that you needed to worry about when you started captaining the ferry, having had 4.5 drinks and about 3 3/4 hours sleep?
No, I didn't think it was a risk.
You didn't think it was a risk?
No, because as I said, I didn't feel still under the effects of alcohol. I've got 33 years experience captaining the ferry. I know when I'm okay to captain it and when I'm not, and that morning I felt fine.
Is the reason that you know when you're okay to captain the ferry and when you're not after you've consumed alcohol because you've consumed alcohol late into the evening before commencing work on other occasions?
No, I didn't.
Well, how do you
I
know?
didn't mean it like that. I know when I'm on top of my game, and I know when I'm not after driving a ferry for 33 years.
I tender that document, Commissioner.
Thank you. I'll mark the voting safety document from the New South Wales Government website, watersafety.newsouthwales.gov.au as Exhibit R2.
Thank you, Commissioner. Now, you understood, though, Ms. Shandy, that it's these sorts of risks of boater fatigue, these sorts of risks, which is why the company has a zero tolerance towards operating a ferry under the influence of alcohol.
Yes, I understand that.
Yes. You could have contacted management when you arrived at work, early 4:30, or even late at night. You could have sent a text message to management telling them about the circumstances that you confronted you. Could you not?
Yes, I could have, but I didn't feel there was a need to.
Well, it wasn't just like any day, was it?
No, it wasn't.
This was a huge event in your life. That's right.
Yes, that's right.
Your husband has just been told, as I understand it, that he hasn't got long to live. Is that right?
Yes, that's correct.
So you've been up having quite a few drinks with you?
Yes.
Could you accept that you could have put a call or sent a message to the CEO saying, look, this has happened, I'm not in a position to work?
I could have done that, but I didn't because I felt that I could go to work that day. I would have told my CEO about the circumstances eventually. I didn't want to talk about it right then and there.
And you would have expected that if you had contacted the company, they would have been pretty accommodating, given the way they've accommodated your needs in relation to your husband.
Absolutely, yes, they would have.
Now, you say that you can't explain exactly what happened when you neared the jetty at 7:30 in the morning. Yes. You only knew something was wrong because you felt the sudden lurch and then you grabbed the wheel and gained control. Is that right?
Yes, that's correct.
Normally you would see if there was a problem through your eyes, would you not?
Yes.
Yes. And that didn't happen here, can I suggest to you, because your eyes were closed?
No, my eyes weren't closed. I don't think there would have been anything to see in this circumstance. I felt like it was just a lurch from within the engine of the ferry. There was nothing to see.
But you felt, well, it sped up, that's right?
Yes.
And you could only speed up if you did something on the controls, is that right?
Either that or if there was some mechanical fault internally.
Yes, assuming it's mechanically in order, it could only speed up by your action?
Yes.
Yes. And it could, assuming it's mechanically in order, it could only lurch by your action or inaction?
Yes, if there was no mechanical fault,
yes,
I think that would be the case.
That's right. And can I suggest to you, you didn't see any of this occurring because you nodded off. Do you think that may be a possibility?
No, I don't think that's a possibility.
Much more, Mr. Moore?
I think I've nearly done, Commissioner. Can I suggest to you, in conclusion, that you were not in complete control of the vessel at all times, Ms. Shandy? You agree with that?
No, I don't agree with that. I was in control of the vessel.
Well, you weren't in control when it sped up and lurched, were you?
No, I wasn't at that point.
No. And it's because you weren't in control that you ran inside the ferry after the incident to check if all the passengers were okay.
Oh, yes, I ran inside to check if they were okay because it would have been quite scary for them.
And people were shaken and some children were crying.
Yes.
And you apologised.
Yes, I did.
You apologised because you knew it was your error.
No, not because it was my error. I apologised because I'm the captain of the ferry and I'm in charge. So I apologised for the incident, but I didn't apologise taking it.
Nothing further.
Thank you. Any re-examinations, Keating?
Just two short matters. Thank you, Commissioner. Now, you were asked some questions by my learned friend about whether or not the vessel was mechanically in order. Do you recall that?
Yes.
Can you describe to the Commissioner if at any point during the period when you were stood down, anyone spoke to you about the vessel or asked you any questions about it? And if so, what those questions were?
No, nobody spoke to me about the vessel or asked me any questions. Nobody spoke to me about anything at all, actually. I didn't have any contact with my employer or previous employer in that period.
Have you seen any reports about the mechanical reliability of the vessel relating to this incident?
No, I haven't.
Now, my learned friend put to you a question about whether it was possible that you nodded off, and you said that you didn't think it was possible. Do you recall that question?
Yes.
Can you tell the Commission, did you nod off?
No, I didn't.
I've got nothing further in the examination.
Thank you. Ms. Shandy, you're excused. Mr. Moore.
I think we've agreed to make submissions at the conclusion of the evidence, Commissioner. I call my first witness and only witness, Ms. Pint. Ms. Pint, would you go to the witness box, please?
Take the Bible in the right hand. Could you please state your full name and address?
Harriet Pint of 24 Slab Road, Stellarville.
Okay. If you could just repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
in this matter before the Commission
in this matter before the Commission
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Mr Moore.
Ms. Pint, for the transcript, could you please repeat your full name and address?
Harriet Pint of 24 Slab Road, Stellarville, in the state of New South Wales.
All right, and you're the Chief Executive Officer of Laga Harbour Ferry Services Proprietary Limited?
Yes, that's correct.
Thank you. Now, Ms. Pint, you've prepared a witness statement for this proceeding dated the 11th of February 2015 of 26 paragraphs.
Yes, I have.
You've got a copy of that there?
I do.
Have you read it recently?
Yes.
Have you got any changes or corrections you wish to make to it?
No, I don't.
Is its contents true and correct?
Yes, they are.
Thank you. I tend to that.
A number of objections, Commissioner, before that document's tendered.
Thank you, Ms Keating.
Thank you, Commissioner. I'll make it quick, Commissioner. It's a single objection that encompasses a number of paragraphs. Paragraphs 15, 16, 17 and 18, Commissioner, are all hearsay. They relate to matters not directly observed by this witness and about which she has no direct knowledge. Now, I appreciate, Commissioner, that we are in a tribunal, and I understand that the rules of evidence don't apply. But this is quite an extraordinary proposition. These are the critical facts that go to proving the respondent's case. And we are dealing with not just the ordinary civil standard here, we are dealing with allegations of very serious conduct to which the Brigginshaw standard applies. And in those circumstances, this tribunal ought not to permit the respondent to come along and seek to prove its case by way of hearsay evidence when there is no explanation at all of why the people who could give direct first-hand evidence of these matters have not been called. I press the objection.
So that was for paragraph 15, 16, 17 and 18.
Indeed.
Yes, thank you. Mr Moore?
Commissioner, as I understand it, none of these matters are in dispute. In fact, the matters deposed to in those paragraphs, the applicant, my learned friend's witness, client, gives evidence about some of those matters. For example, 18, the first, where Ms Pint says the first indicative test showed Ms Shandy had a blood alcohol concentration level of 0.019. That's not in controversy. Paragraph 20 of Ms Shandy's statement goes to that. And likewise, paragraph 17, I understand that to be the substance of what the applicant says in her statement. So I don't understand really the foundation of the objection.
Thank you, Mr Moore. Anything further you want to say on that?
Nothing further, Commissioner.
Ms Keating? I'm going to, on the basis that certainly paragraphs 15 and 18 are both matters that are not subject to controversy, and it seems to me were admitted by Ms Shandy. I'll allow those in on that basis. With respect to paragraphs 16 and 17, I'm going to allow those in. I'll take submissions as to weight, as you see fit, Ms Keating.
As the Commission pleases.
I'll mark I will mark the witness statement of Harriet Pint consisting of 26 paragraphs dated the 11th of February as Exhibit R3.
Thank you, Commissioner.
Ms Pint, you've known my client for many years, haven't you?
Yes, I have.
And she's always been a very good and diligent employee.
Yes, she has.
And until the events that led to her dismissal, she had an excellent service record, didn't she?
Yes, she did.
She went above and beyond in her duties.
Yes, she did.
She assisted you in training apprentices.
That's correct.
She gave up her own time to assist the company to do that?
Yep.
She had an excellent attendance record?
Yes.
And in fact, across 33 years, your company didn't have a single complaint about my client's employment?
No, we didn't.
So you understand then that this is a matter of critical significance for my client?
Yes, I do.
And when you prepared this witness statement, you prepared it fairly?
Yes, I believe I did.
And you understood the significance of coming to the tribunal today and giving this evidence?
Yes, I did.
And you included in your witness statement all of the matters that you thought were relevant that the Commission needed to know about, didn't you?
I believe I did, yes.
You didn't leave anything out that might have a bearing on the matters that we're discussing today, did you?
Not to my belief. I am a CEO. I'm not highly experienced in these matters, but I believe I put in everything that's relevant.
To the very best
Yes,
of your knowledge,
that's right.
you believe you made all the inquiries you needed to make to give this statement today?
Yes, I do.
And you accept the seriousness of the task of putting in this statement?
That's correct.
Thank you. Now, it's true that your company is the only ferry operator on the island?
Yes, we are.
And to the best of your knowledge, there is no other company on the island that employs ferry captains?
Yes, that's right. We're the only ferry provider that goes from South Island to the mainland. It's Sellerville. We're very proud of that.
Now, you employ a Mr. Carlton Druff.
Yes, we do. He's our safety officer.
And it was Mr. Druff who spoke with Ms. Shandy on the morning of this incident. That's correct, isn't it?
Yes. The incident was reported to our harbour master, and then Ms. Shandy met with Carlton Druff.
Yes, and you weren't there that day, were you?
I arrived later, but I wasn't there initially.
Yes, and you didn't have a conversation with Ms. Shandy that day, did you?
I believe I did have a conversation with her.
Did you? Is there any reason why you didn't put that conversation in your witness statement?
That must have been. I'm just having a look.
Well, I'm sorry, Ms. Pint, you've just given evidence that you took great care in the preparation of this statement, haven't you?
Yes, I did. I'm just having a look. It doesn't appear that I've put it in there.
No. And so you now accept that, in fact, this statement doesn't include all of the relevant information, does it?
Well, I object to the question. It comes from a presumption which hasn't been established on the evidence, which is that the substance of the conversation had any relevance. That hasn't been put to the witnesses yet.
It would be an extraordinary proposition if a conversation this witness had with my client on the day didn't have relevance, but I'll go around it that way. At what time did you have the conversation with my client, Ms. Pint?
I believe. Sorry, if you could bear with me for one moment. I believe I was with Ms. I do apologise.
You don't recall, is that it?
I believe
Ms.
I've got
Pint?
myself confused, perhaps. Yes.
Yes, all right. So you accept that perhaps your statement isn't a complete record of your involvement in this matter?
Perhaps that's correct.
Now, are you aware of any reason, Ms. Pint, as to why Mr. Druff can't be here to give evidence today?
We decided that I could represent the company.
I see. So it was a positive decision taken by the company that you would be the person to come along and give evidence?
Yes, it was.
And are you aware of any reason why I withdraw that question? Is Ms. Schooner still employed by the company?
Yes, I believe she is.
Are you aware of any reason why she was not able to come and give evidence today?
No, I'm not aware of any reason.
See, Mr. Kevin Kegg, is he still an employee of the company?
Yes, he is.
Is there any reason why he couldn't come and give
No.
evidence today?
Not that I'm aware of.
Now, I'm going to ask that the witness be shown Exhibit R2. Ms. Pyatt, you were in the room when your counsel handed this document up. Are you familiar with it?
Yes, I am.
And so you're aware that the law provides a blood alcohol limit of 0.02 for commercial vessel operators?
Yes, I am.
So in fact, your company's policy is more stringent than the standard applied by the relevant legislation, isn't it?
Yes, it is. We place safety as our highest priority, and we've developed a policy in line with that provides for zero tolerance.
Is that the policy that was tendered by your counsel earlier in this proceeding?
Yes, it is.
Now, it's an occupational risk, isn't it, when you have employees starting early in the morning, that they might be tired if they didn't get enough sleep the night before?
Yes, they could be tired.
Yeah, it's an accepted risk in your industry, isn't it?
That they might be tired, yes. I guess that's a reality of life, that people can be tired.
Yes.
So I'd accept that.
And again, if you've got employees commencing at 4:30 in the morning, you'd accept that there is a risk that they may have consumed alcohol the previous night.
Yes, they could have consumed alcohol, but that's strictly against our policy, and it's clearly stated in our policy that we have zero tolerance, and that employees can't work under the influence of alcohol.
Well, can you show me in the policy where it says that they're not permitted to drink alcohol the night before a shift?
Does the witness have a copy of the policy?
Oh, I apologise, Commissioner. Could I ask that the witness be shown Exhibit R1?
Sorry, could you ask the question again?
Yes, of course, Commissioner. I apologise. If you can take a moment to look at the policy.
Yep.
Could you please show me where in the policy it states that employees are not permitted to drink alcohol the night before a shift?
The policy doesn't state those exact words, but the policy provides that as part of it, I'm just reading a certain section,
Yes.
All employees must not be under the influence of alcohol while working. It also provides further down that no employee will be allowed to work under the influence of drugs or alcohol at any time. So I'd say that that's clear that you can't be under the influence of alcohol. So the intention, or
Yes,
it
so
might have
the
been
policy
elevated.
provides you can't be under the influence of alcohol while working.
Yes.
But you rely on your employees to make that assessment themselves, don't you?
Yes, we do. I haven't got the whole policy here, but from the part we have here, it doesn't seem to say anything about it.
Yes. There's no checklist at sign-on that requires an employee to set out what they've done the night before, is there?
No, there's no checklist.
No, there's no checklist at sign-on that asks an employee how many hours sleep they've had.
No, there isn't.
There's no self-test facilities that lets an employee test for their blood alcohol level, is there?
No, there isn't.
So it's true to say, isn't it, that the company has this policy, but it relies on employees to determine for themselves whether or not they're complying with it.
Yes, it does.
And you'd accept then that the company accepts the risk that an employee might make a mistake.
I'd suggest that they could raise that as an issue, or they could raise that with someone at the company.
Yes, but again, you rely on the employees to make that assessment as to whether or not to raise it, don't you?
Yes, I do. We also rely, it mentions that other employees have a duty to report. I'd suggest that if an employee had consumed alcohol the night before, they know that they need to be wary. We do go through this policy as part of our safety training sessions.
Yes, of course.
They're required.
Even accepting that an employee needs to be wary, you nonetheless accept the proposition that you rely on employees to self-monitor their compliance with the policy.
Yes, I do, prior to their commencing their shift.
Now, you mentioned that you train your employees in this policy, in its requirements.
We go through the policy as part of our safety training.
Yes, and you do a refresher every year.
Yep, that's right.
And you describe it as a zero tolerance policy.
Yes, the policy states that it's the zero tolerance as to drugs and alcohol, so I'd agree.
And can you tell the Commission what your understanding of a zero tolerance policy is?
My understanding is that you can't have any level of drugs or alcohol that's over a zero blood alcohol reading in relation to alcohol and the applicable reading in relation to drugs.
So there's no room to move. If you're in breach of the policy, that's the bottom line.
Yes, the policy states that you can't be under the influence of drugs or alcohol, that's correct.
You'd also agree with me, though, that the policy provides that a breach may initiate action up to and including the termination of employment, doesn't it?
Yes, it does.
It doesn't mandate termination of employment.
No, it doesn't.
So you would accept that, in fact, it's not zero tolerance leading to dismissal.
No, it's zero tolerance. I would say that relates to if you don't abide by that zero tolerance, it's a breach of the policy, and then that can initiate action up to or including termination. So I'd agree that termination doesn't necessarily follow.
Yes. And so if termination doesn't necessarily follow, you agree with me then that there could be lesser sanctions applied under this policy?
Yes, they could.
And that would be consistent with the terms of the policy?
Yes, it would.
And a sanction might be applied that was less than termination, taking into account the severity of the breach, for example?
Yes, that would be a factor.
And it might also take into account the personal circumstances of the employee leading up to the incident?
That would be another factor among others that could be considered and would be considered.
Yes, and all of those factors would require you to conduct a thorough investigation, wouldn't they?
Yes.
And one of the things you would do to be fair to the employee who might be facing termination of their employment is to speak to them.
Yes, we would.
Now, can I ask you to look again at Exhibit R1, which you have in front of you, which is the dismissal letter. You would agree with me that you didn't, I withdraw that. You would agree with me that it's not true to say that you had no option but to terminate my client's employment.
We believe we had no option because safety is our number one priority, and Sarah had control of the ferry. She had a lot of people's safety in her hands, and despite her personal circumstances and her excellent service up to that point and other factors, we felt that we had no choice. We could exercise no discretion. We had no choice in this matter but to terminate.
You did have a choice, didn't you? You didn't have to terminate. There was no law requiring you to terminate.
No, there was no law, but we placed safety first, and as part of that, we felt that we had to terminate her employment.
Yes. But you would agree with me that even though you felt you had to, you didn't have no option.
Well, if you're referring me to that section of the drug and alcohol policy, I'd agree. It says that there can be action up to and including termination, so that implies that other things.
There were other options available to you, and you elected not to take them.
Yes, we did elect not to take them.
You agree with me that you could have given my client a final warning, for example?
We didn't feel that a final warning was appropriate given the severity, given her senior position and the fact that she has control of the ferry.
You agree with me that it was open to you as an option to give her a final warning?
Yes, it was open, but we didn't feel it was appropriate.
You agree with me that you could have, in fact, placed my client on a period of agreed leave?
Once again, we didn't feel that was appropriate, but yes, it was open to us.
You agree with me that you could even have sat down with my client and considered her personal circumstances and arranged some counselling for her, for example? That was an option available to you?
Yes, it was an option, but as I said, we didn't deem that appropriate.
Now, you asked my client to attend a meeting on the 16th of January 2015, is that correct?
Yes, I did.
And when my client attended that meeting, she was handed a letter informing her of her dismissal, wasn't she?
Yes, I did hand her a letter, that's correct.
And that is, in fact, the first occasion on which you spoke to my client about this incident, isn't it?
I believe that was the first time I spoke to her looking at my statement, but Carlton Druff, our safety officer, had asked her what happened on the day, and we got her contemporaneous account of what had happened at that time.
Did you make notes of that contemporaneous account?
I didn't have that conversation.
Did Mr. Druff make any notes?
I'm not sure. I think he might have, but I'm not able to.
Ms. Pint, you conducted the investigation into this incident, didn't you?
Yes, I did. I don't know though if he made notes. I'm aware that he spoke to her.
Well, did you inquire from him as to whether he made any notes?
I can't recall my response to that.
You'd accept, though, that my client's contemporaneous account of what occurred is fairly critical to an investigation into a matter of this seriousness, wouldn't you?
Yes, I would.
And you accept that you didn't make that inquiry?
I can't recall, but I might not have made that inquiry, but I conducted the investigation with Mr. Druff.
Yes, and as part of that investigation, you spoke to a number of employees.
Yes, we did.
Did you take written notes of those conversations?
I think I did take written notes of my conversation with Alison and Kevin. Alison Schooner and Kevin Keeb.
Do you still have those notes?
I believe I do, but I don't have them with me.
And those notes, do they set out the substance of your conversation with those two witnesses?
I believe they do.
I'm going to call for those documents, Commissioner. One of the critical elements of this case is what occurred while my client was on the ferry and it lurched starboard. I confess, Commissioner, I don't know which way that is. Probably not material. The allegation is put for the first time today that in fact my client was responsible for that incident. It doesn't appear in the letter dismissing her. If my learned friend wants to rely on it, we should see the notes, the contemporaneous statements from direct witnesses about what occurred. I call for the documents.
Mr. Moore, do you have anything to say on it?
No, I can't resist that.
Yes. I will order that the notes taken by Ms. Pint during her investigation with the two employees in question be produced
Yes,
as a
we'll
matter
attend
of
to that
urgency.
as soon as possible.
Thank you.
I'm grateful to my learned friend. Now, having conducted the investigation and spoken to a number of people, it's true, isn't it, that what Ms. Schooner told you was that she observed that my client was tired but otherwise didn't notice anything out of the ordinary. That's correct, isn't it?
Yes, I think she said that she was tired and appeared somewhat distracted, but that apart from that, she seemed to be, yes, nothing out of the ordinary.
Yes, and Ms. Schooner said that she didn't observe any behaviour that she felt warranted a report to the company, didn't she?
Well, I guess you can imply that from the fact that she thought there was nothing out of the ordinary.
Well, that's the inference that you drew from her evidence.
Yes, that's right.
And the same goes for Mr. Keeg, isn't it? He said that my client was tired, but otherwise he didn't observe anything unusual.
Of her appearance, yes, I believe that's correct.
Thank you. Now, you didn't get a mechanical report on the ferry, did you?
No, we didn't. It wasn't raised with us that there was an issue.
And
the
it wasn't
mechanics of the
raised with
ferry.
you because you didn't speak to my client, did you?
Carlton Druff spoke with Sarah after the incident in his office.
And he spoke to her briefly on that day?
I think he spoke to her for a reasonable time. I don't think it was brief. This was quite a serious event for us. So
But you can't tell us the contents of that conversation, can you?
I wasn't there.
No. And you don't know whether he took any notes about it because you didn't ask.
I can't recall. So
See.
Sorry, Ms. Keating, is there much more?
One more point, Commissioner, if I might.
Thank you.
Now, you've agreed with me that the First time you spoke to my client about this incident was the day she was dismissed.
Yes, I do.
And you say that one of the relevant factors you took into account was her husband's illness. Is that correct?
Yes, we did consider that.
And you knew that because my client had previously told you about his condition.
Yes, we did, and we've been very accommodating because we do understand it's a terrible situation, so we've been accommodating of any leave she required. That's right.
And we accept that to be true. But in fact, you didn't know when you made the decision to dismiss my client from her employment that the previous day her husband had been told that cancer had spread, did you?
No, we didn't know that, but we did consider her personal circumstances, including her husband's cancer, and another one of the factors we considered was her wonderful service up to that point. But when safety is, when you weigh that up against safety, those personal circumstances.
I'm going to ask you to stick with the question I asked you, Ms. Pint. You did not know that her husband had been told the previous day that the cancer had spread, did you?
No, but...
And the reason that you didn't know is that you didn't ask. That's correct, isn't it?
We didn't ask specifically if anything had happened with her husband the night before.
Well, you didn't ask her anything, did you? Because you didn't meet with her before you dismissed her.
Well, Carlton Druff spoke to her, but I didn't speak to her, so
And
I couldn't comment on that.
So you also agree that you didn't know that her husband had been told it was not worth continuing his treatment, didn't you? You didn't know that, did you?
I believe at that time we weren't aware. We were aware of the situation with her husband.
So you weren't aware of that fact, were you?
Sorry?
You were not aware of the fact that her husband had been told the previous day it was not worth continuing his treatment?
I wasn't aware.
It's yes or no, Ms.
I wasn't
Pint.
aware.
And the reason you didn't know was that you didn't ask.
Well, I didn't speak to the applicant, or to Sarah on that day. So.
Or you didn't speak to her at all before you dismissed her, did you?
Excuse me, Carlton Druff spoke to her.
My
but no, I
question is,
didn't.
did you speak to her before you dismissed her?
No, I didn't.
Got nothing further.
Thank you. Any re-examinations, Mr. Moore?
Yes, one brief matter, Commissioner. You were asking questions about why you elected not to take or not to impose other sanctions on Ms. Shandy short of dismissal,
Yep.
warning, and I think some other examples were given. Can you tell the Commission why you decided that dismissal was appropriate in all the circumstances?
We decided that dismissal was appropriate because despite we noted the personal circumstances of Ms. Shandy, including her husband's cancer, her long record with our company, and she was a very valued employee up to that point, and she'd had an unblemished record. But we're in a dangerous business, and ferries are immensely powerful. Our ferry captains are they have the safety of our crew and our passengers, other users of the water, and, for example, people on the ferry in their hands. And we felt that in this circumstance, with the significant breach of our policy, of which Sarah was aware, that in this case we couldn't afford to make any concessions, and that strict application of our policy had to apply, and that there was no room for discretion. That's why we decided to make the decision, which was difficult for us, but we made the decision to dismiss the applicant.
Nothing further, Commissioner.
Thank you. Thank you, Ms. Pint. You're excused. We'll take final submissions.
Thank
Brief
you.
Final submissions.
Commissioner, we'll make them very brief. We did extensive openings, as I recall, and I believe you also have some written submissions before you, so we will keep our closing submissions very short.
Thank you.
Commissioner, the factual background to this matter is almost entirely uncontested, and I won't take you through it, save to a number of critical points. The first is this. A point I made in cross-examination recently. There are a number of people who can give critical evidence about this matter, and there was a concession from the CEO of the respondent that a decision was taken, a strategic forensic decision was taken not to call those people to give evidence. In circumstances where serious allegations are made against my client, and we're dealing with a Brickenshaw standard of proof, I submit to you that that is not an acceptable means of calling evidence, and that the appropriate thing to do is to give no weight to those passages of Ms. Pint's evidence as are hearsay, and also to draw an inference, a Jones and Dunkell inference, that the evidence that the three witnesses who are absent could have given would not have assisted the respondent's case. Within that framework, Commissioner, we come to the first of what I say are the contested matters, and that is the incident that involved this ferry lurching to starboard. What we have now seen after the evidence has been called, that there was little, if any, inquiry into that incident. What there was an assumption that it was my client's conduct that led to that incident. But it's conceded that there was no mechanical report into the vessel. It's conceded that there was no inquiry whatsoever into other potential causes. It was assumed that my client was responsible for that incident. Now, that issue must be resolved in my client's favour. First, for the reasons I've just outlined, the lack of evidence from the direct witnesses to the event. But second, the reality that my client was not spoken to about the incident. She is the person best placed to tell the employer what happened on that day, and if it was not satisfied with her explanation, then it was open to it, and indeed incumbent on it, to get expert information, or at least a thorough investigation into the causes of that incident. That being the case, this Commission cannot be satisfied that my client's attendance at work that day above 0.00 had any effect whatsoever on her performance of her duties. Now, that is backed up by what we do know about what the other witnesses said in the investigation that was conducted. My client appeared tired, but in the 3 crossings she did before that incident, before she was stood down, no employee of this organisation that trains its staff, refreshes its staff, promulgates policies, treats safety very seriously, not one of the people on that boat felt the need to say anything about my client's conduct that morning. The only conclusion that can be drawn is that whatever her condition was, she was performing her duties safely, competently and diligently. Now, it's not contested that my client went to work with a blood alcohol of more than 0. It's not contested. The circumstances that led to that event are not contested. But 2 things need to be said. The first is this. This is a case of rigid application of policy. The word zero tolerance, Your Honour, cannot displace the statutory test, which is, was there a valid reason? All of the policies in the world cannot countervail the statutory test. In that circumstance, it's not enough to point to a policy and say, as the witness Ms. Pike did, we had no discretion. An employer always has discretion, and whether or not there's a valid reason, in fact, isn't determined by what a policy says, but by all the circumstances of the case. Now, in this case, we have a breach of the policy that is conceded. We say it's a breach at the lower end of the policy. We say there were no measurable consequences to the breach. Nobody was harmed. There were no consequences at all.
Is the potential harm not something I should consider?
Of course, Commissioner, of course. You should consider potential harm, but through this prism. My client has been doing this job for 33 years. In the evidence she gave you, she said that she knows when she's fit to work and when she's not. We're talking about shift workers who get up early, who face the difficulties of sleeping with circadian rhythm patterns. These are workers who are very, very well adept at assessing their own capacity. She's done it for 33 years without incident, and on this day, she judged that she was fit. Now, critically, Commissioner, we have what is said to be a zero tolerance policy, but an admission from the CEO of the company that it's up to the staff to manage it themselves. There's no checklist at sign-on that asks how many hours sleep, how are you feeling, did you consume alcohol? There's no self-test facility for employees to self-test if they've had a few drinks the night before. Employees are left to do their best to manage themselves, and from time to time, somebody gets it wrong. My client got it wrong. But in circumstances where she got it right for 33 years, where she has an unblemished service, not only unblemished but commendable service, and in light of the very difficult personal circumstances that I won't go into, the minor breach of the policy in those circumstances did not justify dismissal. Didn't find a valid reason for dismissal. As to the second point, I think the procedural fairness point came out clearly in the evidence. Between my client being stood down and my client being dismissed, no one spoke to her. The allegations weren't put to her, her views weren't sought, she had no opportunity to respond. That point speaks for itself, and I'll say nothing further. As to the final point, Commissioner, you could be against me on all of that, and my client should still succeed in this application. Because after 33 years, she should not be reduced to a single mistake. A single mistake should not outweigh the 33 years of good, diligent, unblemished service that my client has given in circumstances where the personal impact on her is so high. No other jobs available for ferry captains on the island. A husband with terminal illness. A small island with limited employment opportunities. And a career that my client has worked at for 33 years. She is more than the sum of a single mistake. And in circumstances where we look to all the circumstances of the case, this is a dismissal that was quintessentially harsh, unjust or unreasonable because of its disproportionate effects on my client as to the conduct she engaged in. We press for reinstatement with full continuity of service and compensation for the wages lost. Unless you have any questions for me, Commissioner, they are the submissions for the applicant.
No, thank you very much, Ms. Keating.
Thank you, Commissioner.
Mr. Moore.
Thank you, Commissioner. The Commission hopefully has the benefit of our fairly extensive outline of argument filed previously and the opening today, so we rely upon those, and what I propose to do now is just respond to some of the critical points my friend has sought to make.
Thank you, Mr. Moore.
As to the proposition that witnesses weren't called and that some of that evidence shouldn't be given any weight, and in fact the Jones and Dunckel inference should be drawn, we'd resist that because the matters about which those witnesses could potentially give evidence were largely not matters which were in controversy between the parties. We don't understand that there's any proper basis for that submission to be made.
There is the important question of the conversation, though, that occurred between Mr. Druff and the applicant.
Yes.
And that seems to be the first conversation that occurred after the accident.
But there's no controversy that there was such a conversation, and the substance of what was conveyed in that conversation is also not in dispute. Now, that was the view, for better or for worse, that the respondent took in the running of this case, but that's our position in relation to that, Commissioner.
Yes, thank you.
It's said by my learned friend that the respondent made an assumption that the incident with the careering ferry, if I can call it that, was my client assumed that she was the cause of that. Well, I think the witness, the applicant, agreed in evidence that she was in charge of the ferry, and the loss of control could have only been caused by either her action or inaction or a mechanical cause. I mean, logic dictates that. Now, so we have this red herring thrown out there in the witness statement by the applicant alluding to a mechanical cause. Well, if she so genuinely believed that, why did she not refer to it in her letter to the respondent complaining about her dismissal?
Well, I object to this. That letter's not in evidence. My learned friend didn't put it to a witness and he didn't tender it. He can't be now permitted to close on material that's not in evidence before the Commission.
Well, I didn't put it in evidence because it was unnecessary to, because I put to the witness the proposition that A, she wrote to the company post-dismissal, she agreed to that, and B, I put to her that in that letter she did not raise anything about the mechanical cause, and she agreed to that. So we say this is fanciful by the applicant to suggest that the respondent has acted on some sort of erroneous logical basis by attributing, golly gosh, to the captain of the ferry the loss of control. Well, that was the obvious cause in circumstances where nothing was said by the applicant until this case about there being a mechanical cause. Now, the next point my friend made, it said, well, none of these other workers on the vessel made comment about her behaviour on the morning. She looked a bit tired, but that was it. We say that that submission rests on a false assumption, namely that someone to be affected by alcohol is going to be staggering around or making manifest their inebriation. Plainly, someone can be affected by alcohol and not show it to the eyes of others. It said, well, there were no consequences from this incident. No one was harmed. The Commission, certainly for my client's part, it does not wait until the occurrence of harm before it takes appropriate disciplinary action in relation to employee behaviour. And it's a staggering submission to hear from a learned friend that it might be the case that a remedy is justified because no ongoing harm was suffered by anyone, and that she shouldn't be punished for more than a single mistake. One might think, well, was that the plea of the captain of the Italian ferry cruise that sunk off the Mediterranean with the loss of 300 lives? Is it the suggestion seriously by the applicant that my client should be constrained from acting in the most severe way in dismissing an employee it's conceded in circumstances where there's a loss of control and no loss of life? It surely can't be right that the determinant of whether or not a dismissal contravenes the Act is whether or not there was any loss of life or any serious consequence. We also take issue with the proposition that there was some failing in the respondent's policy in respect of drugs and alcohol because employees were left to self-manage, as it were, and self-test and ensure their own compliance with that policy. Well, indeed that's so, because this is not the nanny state, Commissioner. Employees, responsible, experienced employees, do need to take responsibility for their own actions. It's clear the applicant conceded that my client took safety as one of the most important considerations in its operations and trained up all its employees accordingly. And yes, it expected that employees would act in accordance with their policies. And in my respectful submission, the applicant, in the context of the emotionally distressing situation she became aware of in relation to her husband the day before, then has, on her evidence, 4.5 drinks in about 3 3/4 hours, and then has 3 3/4 hours sleep, that was a clearly reckless set of events that she was the author of. And she had a way of avoiding it. She just needed to pick up the phone and contact my client. And as she conceded, my client would have done the right thing and accommodated her needs. So when one comes to the other circumstances of this case, and the plea of long service and clean record and so on and so forth, well, we say that those matters are not determinative in any way and shouldn't be given any particular weight, because this is a case of misconduct. This is a case of failure, profound failure, and that needs to be the central, weighty focus of the Commission's deliberations with respect. And that insofar as other considerations are relevant, we say that the other considerations concerning her husband's ill health and her long service are largely, if wholly, offset by the very accommodating position my client has taken towards the applicant throughout the unhappy circumstances involving her husband, and by the applicant's personal recklessness in the evening in question, which led to this most dangerous of incidents. So we ask the Commission to dismiss the application, and certainly for the reasons I said at the outset, to not award reinstatement if the matter gets that far. The Commission pleases, unless there are any questions for you from you, Commissioner, they are the submissions of the respondent.
Thank you very much, Mr. Moore. Anything briefly in reply, Ms. Keating?
Nothing in reply, Commissioner.
Thank you. I'd like to thank the parties for their advocacy in this particular matter. For the sake of the audience, I'm not going to tell you what the decision is. I thought that what we might do is see if anyone here wants to provide their assessment of the evidence and whether they think that Ms Shandy should be reinstated if she was unfairly dismissed. Does anyone want to make a comment about what they've heard? There's not necessarily a right and wrong answer.
Can we do it by show of hands?
Okay. Okay, so who thinks that she was unfairly dismissed? Put your hands up.
I'll take a jury verdict on this one, Commissioner.
And who thinks? How many think that she deserved? Well, that her application should be dismissed. That she shouldn't. Yep. Does anyone want to say? Does anyone who's put their hand up just want to sort of say why they think one way or another?
Yeah, my biggest issue with it was saying basically that that you could monitor over 33 years. You've monitored your own behaviour and everything like that, and that when you're right and you make one mistake. My question would be: is that going to be then a recurring behaviour? Is that a failing of your personal circumstance, and it's led you to your inability to self-regulate that behaviour anymore?
Yeah.
I think there's 2 points that came out for me. One was, I think the issue fails in my view on the procedural fairness, that she didn't get the opportunity to put a case, and that it appears that an investigation was based simply on the readings of her blood alcohol level, which I think would have been really good to lead the evidence of the depreciation of alcohol through the system, and to say, as they made the point, that she must have been significantly higher than that at the time she started. She was to have worked out the system. But where the issue of this self-monitoring, I mean, the police require us to self-monitor when we're driving a car, and there's a zero tolerance there. If you get busted for drink driving, there's no tolerance in that. You get suspension of licence, that sort of stuff. So this idea of the point made by the applicant that self-monitoring was inappropriate, well, it's the system that gets used, and there is that. So I think my view was like that. I believe that she was fairly dismissed, but procedurally the application would fail because of the procedural fairness not afforded to her. So I think both answers.
Yeah. Anyone else?
Yeah, I believe that similarly the procedural fairness, because it wasn't followed, I thought that was a fatal flaw. Sorry, and also I believed it was too harsh given her circumstances and the news she received the prior night. She, as part of the procedural fairness, she never was given an opportunity to convey that information. And also the policy allowed for that flexibility, even though it said 0%, there was that flexibility for something else. The fact that she probably, unfortunately, she doesn't look as though she's been driving a ferry for 33 years.
It's the healthy lifestyle on the island.
Yeah, well, she's drinking alcohol every night. She's looking a lot older than that. So, and also the fact that her job prospects are probably not too close shot. You've probably lost all your credibility on that little island anyway.
Yep. In the.
I think I agree with the other statements that procedurally it was quite unfair because she didn't get a chance to respond. But I think it's also important to remember that the policy provided that she could be terminated for a breach, and it's within the employee's discretion to affect that policy and terminate if they need to. And that safety, especially in this industry, is so important. And if she breaches, well, the employee's discretion to terminate. So that's what it is. Even though it was harsh, I think. But.
Yep. There was someone up the back. Yep.
Yeah, I also thought that I agree with all the other comments as well, but the issue of the legal limit for alcohol, I think was 0.02.
0.02, I think, was the state.
I think she was 0 alcohol. So it seems that it's like, yes, we'll have an obligation to ensure we follow the law and drive a car, but we are deemed by law to be fit to drive a car up to 0.05. Anything over that, we are deemed by law not to be fit. So with the same principle not apply here, and whilst it's a policy breach, it doesn't fit within the framework of the laws, therefore it would seem to be harsh.
In the blue jacket? Yes.
I also think there wasn't enough evidence shown today to show that there actually was investigation wasn't conducted by the respondent, so they weren't actually able to determine whether or not it was their fault or the applicant's fault for dismissal or for the accident.
And certainly, I mean, one of the difficulties in this situation is that we have a limited time to do the exercise. We could have been here for quite a few hours, believe me.
We'll get that evidence on here.
Yeah. Ms. Keating, do you want to make any comment about how you think it went?
Well, a couple of things. First, as you can probably tell, where's my witness? Where's my opposing witness got to? I'm sorry about that. As an advocate, I forgot you guys were here. So after about 5 minutes, I decided I was actually running the case. So I gave you a very hard time, and I'm very sorry about that. But that's, I appear before the Commissioner quite often, and should tell you that that's actually pretty much my style. So I think it was reasonably representative of how it would play out. And the quite aggressive approach I adopted, for which I now apologise, is precisely how I would manage a witness in this circumstance where there are countervailing factors. So a few people have made the point about, and I think Stephen put it really, really well in closing, that this was a reckless thing to do. Alcohol, tiredness, a really supportive employer, but that's the point for the respondent in this. So I have to countervail that by making the respondent seem as unreasonable as possible, and the only way to do that is to box the respondent into a corner and be quite aggressive in the way that I cross-examine. So that's a forensic choice about how to deal with the weak point in my case, which was always going to be the reasonable kind of employer who's been doing everything possible. So the line of attack was clearly a surprise to the witness, so not very well prepared by her senior counsel perhaps. And it made it very difficult. If that was a real case, the witness would have been prepared for that point, and it would not have come out quite as well as it did for me tonight. So had the witness been really prepared for that attack and they could have met it, then it might actually have swayed people's views.
Sorry, I just wanted to add, in the code of conduct for the drug and alcohol policy, it says under the influence, but it doesn't say must have a reading under 0.00, what the reading should be in conjunction with the legislation for New South Wales driving vessels and things like that. So I guess under the influence is open to interpretation, so what might affect me might not affect the next person as well. I might have to drink but not actually be under the influence. So I guess that's kind of up for interpretation. It's not clear what every view should be.
And that's almost the bigger debate that's occurring about drug and alcohol policy in the workplace, about the difference between being under the influence and being impaired.
Yeah.
So you might have alcohol in your system, but does that impair you? So are we talking about impairment, or are we talking about having no presence of drugs and alcohol in our system? And it's a debate that's playing out in the workplace now and in matters before the Commission. Yeah. Do you want to make any observations, Stephen?
Look, it's been a lot of fun, and apologies for being a bit of a bully. But as please accept my apologies. But it is, in my experience, quite important to go with your strengths, and my strength was the conduct, the incident itself, the alcohol. So I wanted to emphasise that and draw everything out I could, and to paint you as reckless and perhaps a bit dishonest too, self-serving. Because there were issues around the investigation, and I thought Siobhan did a very good job in, and don't take this the wrong way, picking around the edges of the controversy of the conduct to identify the weaknesses around the procedure, and that's absolutely the right angle to take, because there were real vulnerabilities there. So you were left with a situation where something pretty poor has occurred, broadly speaking, but the respondent hasn't really handled the matter properly, and we didn't really have, in the narrative of events, much to say about that, and Lara had to sort of deal with that exposure very well, and I'll prep you better next time. But yes, that was good.
there any questions that anyone wants to ask of the advocates or of me?
If you're saying that these sort of cases are quite common, and I'm sure they are, what is the theme of decisions coming out of the Commission for cases such as these?
Fortunately, I haven't been faced with any of them myself. The main controversy in the Commission has been around the questions of how you test. So what's the basis of testing? Is it saliva testing? Is it urine testing? What facility, the question of the facilities that the employer has that enables people to be tested and how they go about testing people. So whether there are truly randomised testing processes in workplaces, whether those randomised testing processes can be subverted in some way, what the secondary testing is if the first test finds the presence of drug and alcohol, and so on. When it comes to unfair dismissal matters, so this type of case as opposed to the general issue of blood and alcohol testing, it becomes a matter of the policy that operates in the workplace, so particularly how clear the policy is, what the training is around the policy. The difficulty with the policy in this case is as someone identified, while it talks about a zero tolerance, it's really not quite clear what the zero tolerance is directed towards. And the fact that it's not a dismissal matter automatically if there is zero tolerance sort of says, well, what is the purpose of the policy? What's it trying to achieve? And it reads like a policy that was written probably 10 years ago and that hasn't been updated to take account of changes. But in unfair dismissal matters, it's going to be a question of what the policy is, what the law is around that issue. If the policy isn't really clear, then where do you go in terms of how the policy reads? Yeah. So there's no clear-cut, and there never is a clear-cut answer in these sorts of cases, which is why we keep hearing them. Any other questions? Yep. Just before I do, I'll tell you the case that this matter is based on, because it is based on a real case. In terms of me making a decision, if I had to make a decision on it, I certainly wouldn't make the decision on the spot, because there are some quite countervailing forces. There are arguments in favour of both sides. The issues that I would need to consider, and I would consider very carefully, would certainly go to the circumstances of the applicant, the question of her husband, how ill he's been, the length of time that he has been ill, and the effect that has in terms of a final decision of a dismissal, or the final effect of a dismissal on the applicant. But she was aware of the policy, she was well trained, she'd been there for 33 years. She should know by now. She's not someone who's only been out of school for 2 years, not experienced in drinking. She knows the effects of alcohol on her. She says that she didn't feel the effects of alcohol, but she was feeling a bit tired. Well, anyone who's been out for a few drinks late at night knows that mixture between tiredness and the effects of alcohol. What she drank wasn't an insubstantial amount. It's probably more than 4 standard drinks. It was quite a session, really. Given her and her husband knocked off a bottle of wine, and he hadn't been drinking for about a year, I suspect she had more than 2.5 glasses out of it. So the fact that she'd had so much to drink and she'd had so little sleep, I think would indicate a fair degree of disregard by her in those circumstances to the safety and the responsibilities that she had. And I think that the respondent was so sympathetic and supportive of her, also went against her, because she could have picked up the phone. There wouldn't have been a question asked in terms of what the respondent had done in terms of supporting her in the past. I suspect, I think that I would have been very torn. You really need, from a decision-making perspective, certainly I need to stand back from everything that I've heard and just digest it and work out where the balance lies. I suspect that I would have found there was a valid reason, and I suspect that I would have dismissed the application. I think, but I'm not quite sure. In terms of the case that it was based on, it was a decision in Christopher Toms, T-O-M-S was the bloke's name, and Harbour City Ferries in New South Wales. The appeal decision, so the matter was dealt with by a single member in New South Wales who reinstated Mr Toms. It went to appeal, and the Deputy President was overturned on appeal. It then went to the Federal Court, and the Federal Court decided not to interfere in the decision of the full bench. So the full bench decision number, if anyone wants the decision number, is 2014 FWCFB 6249. So that's the full bench decision, and that'll refer you back to the initial decision. And the Federal Court reference is 2015 FCA FC 35. Yep.
One question. If you had decided that the application was upheld, would there have been any other outcome than reinstatement?
I suspect that the respondent would have argued quite strenuously that it was such a breach of trust that reinstatement was not an appropriate remedy. It would be a really tough one, but 33 years of an unblemished record, being in an industry in which there were so few jobs available, you might think that on balance reinstatement was a reasonable thing to do. I think that I would probably go down the reinstatement path.